Hello and welcome to a special one-off edition of Bracewell's Environmental Essentials webinar series. Today we're going to be talking about EPA's Risk Management Plan program and specifically the final rule that EPA issued amending the RMP rules on Friday, March 1st. I'm Whit Swift with the Bracewell ELR team's Austin office, and I'm joined by my Houston colleague Stephen Cook, who will undoubtedly enrich our discussion today about these RMP changes with insight from his decades of working as EHS counsel for a major international chemical company, as well as his time serving as the Deputy Assistant Administrator of EPA's Office of Land and Emergency Management. Thank you for joining us. Now, we have titled this presentation Round 3 because it really represents EPA's third final rule making changes to the RMP program over the last 6 years. And we want to focus on the changes that have been adopted rather than the history. But this slide provides for you the basics of what has happened. The EPA, during the Obama administration, adopted a relatively broad series of changes to the RMP rule. And that final rule was not published until after the 2016 election. Then, during the Trump administration, EPA promptly commenced a reconsideration proceeding, the result of which was a final rule that rescinded most of the changes that had been adopted in the Obama administration 2017 final rule, though it did retain two important changes. They're noted there on the slide. First, activities associated with emergency response preparedness, as well as a requirement to hold a public meeting after what is deemed an RMP reportable accident. Everything else was rescinded. And then, following the 2020 election, you have the Biden administration EPA revisiting the RMP rule once again. And this analysis or evaluation by the Biden administration, of course, is informed with the administration's sort of twin priorities with regard to environmental matters. That is environmental justice and climate change. Climate in particular doesn't seem like a great fit for the RMP program, but we will discuss how EPA has nevertheless shoehorned it into at least some of these new changes to the RMP program. So in 2022, EPA proposed changes to the RMP rule in its Safer Communities by Chemical Accident Prevention rule, and that this proposed rule is what was recently adopted again on March 1st. And not surprisingly, the SCCAP rule undoes much of what was done in round 2 and reinstitute many of the changes that had been adopted in round 1.
What's interesting, when you look at the basis that EPA justified these changes that they've finalized, is the switch that occurred from the 2019 in round 2 to here in round 3. Round 2 was very much a compliance-driven approach. The idea was that to get more facilities to actually comply with the existing requirements as a way to continue to drive accidents lower. It's very much driven by data analysis of the fact that throughout the 20 plus years of the program, accidents in the regulated industries had continued to go down. And you were seeing that trend. What they've done in round 3 is kind of switched to what they call a rule-based, prevention-focused approach. And so as we go through these provisions, you need to think about it from that perspective is how EPA is viewing these changes. The other key aspect that they're doing is they view the community and the employees as part of the compliance assurance mechanism, if you will. Not really true enforcement, but that they are eyes and ears looking at what a regulated entity is doing, and that their participation in the RMP process will help facilitate facilities compliances. So that is another aspect of this that is different from the prior rounds, that real involvement they're looking at from the community. A final thing you will see in all this is that there's not a lot of data driving this. You'll see throughout this rule, has been the case in most of the changes EPA has proposed in RMP over the years, there's a lot of belief. In the preamble, they said, we believe this will occur. There's not a lot of underlying data analysis to go with it. Although a lot of what they have proposed is consistent with some of the accident prevention aspects that you see in the literature and over in OSHA. And that's the final thing, is that as they get more and more into what's happening on, if you will, the manufacturing floor or in the process, the line is getting blurred between what OSHA does and what EPA does. And that's going to be a challenge for companies going forward and how to keep that straight. EPA claims they have coordinated extensively with OSHA, but I don't think historically OSHA inspectors and EPA inspectors receive the same training. And so you could end up with a real divergence of what seemingly are similar requirements, but how they're looking at, because the activities at the process, if there's not an accident, it does protects the employees, which is OSHA's concern, but also protects those outside the fence. So it's understandable that there's some overlap, but the way EPA has gone about it, it's going to present some challenges for companies.
Thanks, Stephen. And for our format today, I'll be walking us through the key changes in Friday's final rule. And then Stephen basically has full license to jump in and better explain the changes, talk about the significance of the changes and compliance efforts that may be required, even to contradict what I've said, actually. This is likely one of the more hastily thrown together webinars we've had, given the recent issuance of the pre-publication rule. So I'll apologize in advance to the extent you find it a bit rough around the edges, but we're going to work hard to have it comprehensive and have some insight here about what EPA has done with regard to the RMP program. Diving into the substance, the first few slides we've got will be reviewing changes that EPA has made to the process hazard analysis, or PHA process, and also the less formal hazard review process that is required for program level 2 processes. And recall that PHAs are required every 3 years for covered processes and must, as the name implies, identify, evaluate, and control the hazards of the process. Everybody out there that's subject to the RMP program should have a mature process in place for conducting PHAs. EPA's final rule adds some new elements to that PHA process. And this first presents the rare climate tie-in between the agency's climate initiative and the RMP program. And that is this requirement that the hazard review explicitly address natural hazards, including those caused by climate change. In addition, and this is an interesting wrinkle to me, EPA here uses the PHA rule to include a requirement that release monitoring equipment have standby power. The idea being that you should not lose your ability to detect an accidental release when you lose power. But it's an interesting wrinkle in the rule to me, because what you see is the inclusion of this mandate in the list of PHA considerations. So, the PHA rule, if you see how it's set up, it identifies these various factors that are to be considered and now we have, in addition to identifying these natural hazards as a factor that is to be considered, EPA is including this shall statement about having backup or standby power.
This was an interesting discussion when I was at EPA. Told them I was agnostic as to why the power went out, whether it was climate change or whatever. I had a flood or the power went down. That's what creates the hazard. So we do it. So I think companies that have sophisticated processes will already covered that. What they'll want to do is make sure that they mention climate change somewhere in their documentation of their process. Use the magic words. In Houston, you can probably not mention avalanches. Don't have a lot of that, but tsunami may need to be somewhere in a word. And likewise out west, if you're in the Rockies, you might need to talk about rock falling. So it's an interesting way EPA's gone about it, but they're checking that box. And so I can see an inspector 5 years from now wanting to see climate change or avalanche or something in a document someplace. But that's probably all that a good company who's got a good system really needs to do about this. The whole monitoring power loss thing it's a story for another day, why they're going down that road.
But it sounds like here, in your view, and that makes sense. If what they want is you've got to have your process safety information and your process of your PHA records showing that you considered the power loss that you were already considering, but from some cause that's tied to worsening storms, more frequent storms, whatever it is. But if you've got the buzzwords in there for climate effects, again, you've allowed them to check that box that will be on their inspection checklist.
Correct.
All right, here's another add to the PHA process, and this is regarding the consideration of inherently safer systems. Now, note this one is limited in scope somewhat. It applies only to refineries and chemical plants there in program 3, but this is a big deal, and this is an issue that's been discussed for years. And I think another interesting wrinkle here, like the last slide, we've got a new aspect that goes beyond consideration of inherently safer systems as part of and includes this mandatory implementation type of requirement. And that's what the bottom of this slide is really talking about. So, for even a further subset of the refineries and chemical plants for which this inherently safer systems review is required, and the criteria there are set out on the slide. If you've got an HF process at a refinery, or it's a covered process at one of these sites that's within 1 mile of another refinery or chemicals covered process, or if you've got a process where you've had an RMP reportable accident since your last PHA. And just to remind everybody, RMP reportable accident, that's different than an RQ type of release. This is not talking about what's reportable to the NRC or an ASTEERS report in Texas or anything, but RMP reportable are those accidents that require you to update your 5-year accident history in your RMP, if it's something of that significance. But if you have a covered process that meets at a refinery or chemical plant that meets one of those criteria, then the inherently safer systems evaluation includes this further analysis of the practicability of inherently safer systems or designs and a requirement to implement at least one passive measure coming from that analysis. Stephen, I know you had some thoughts on this based on our discussions prior to putting together this webinar.
Well, there's two real stretches here by EPA that are new. One is this additional requirement coming to you because of who your neighbor is, that, who's outside your fence, i.e. you're near another RMP facility, comes in. So that's their community-based focus, that you see the write-up that those communities are more at risk, therefore you should do more, is the theory. And then actually making a requirement to do something with the inherently safer technology review. I can see this over time, if EPA is successful in this and the likely court challenge, it survives, this will creep. Passive measures are one level below in the hierarchy of going all the way to the inherently safer technology. So they went up the chain a bit, but try to do it in a way that is not going to be all that expensive in their mind, the way they've done the analysis, but it is an actual requirement to do something different than what you did before, which is new in the RMP program. And if that holds, you can see the agency over time adding more and more to that.
Yeah, it is really interesting to me to see these areas where something has morphed from a consideration to a consideration and a mandate. Another new aspect of the PHA process, and or at least maybe this one might be more. In some cases, it's a new aspect. Some cases, it's some might call it a clarification or an expansion. But stationary source citing. Now, stationary source citing is currently identified as a consideration of the PHA processes for Program 3 sources. But what you've got in the rule that EPA just adopted is a more explicit statement of what that stationary source citing has to include, looking at placement within the facility, looking at hazards posed by proximate facilities, again, what Stephen just mentioned, and then also looking at the proximity or consequences posed by the proximity to public receptors. So we've got an expansion of what is required for the citing valuation done as part of Program 3 PHAs, and an all new requirement that for the hazard reviews for Program Level 2 processes, you've got to include this new citing analysis.
This is one area where you could see OSHA and EPA getting a little bit at odds as you try to meet the objectives. Particularly the chemical refining industry went through a huge facility citing after the accident down in Texas City. And that addressed keeping operators and workers away from the processes. Didn't focus very much on off-site consequences. Well, the EPA perspective, facility siting is about the off-site consequences of the incident. And so for existing facilities where you put, you're not going to move the ethylene furnaces. There they are. But when you start thinking about storage or a new process unit, it isn't just about now keeping the proper distances between the control room and the process unit. You have to think about distance from the process unit or the storage tank or the rail yard to the neighbors on the other side of the fence and think about that. So there's a possibility you could get a little dynamic where OSHA facility siting pushes you one direction, EPA facility siting pushes you to a different decision. So that's something companies are going to have to think through as they look at siting new facilities and new chemicals. And that's more likely to be initially storage, transportation related type things. But over time, although technically transportation is not part of this rule.
Right. But yeah, there is certainly the potential for this process to balance what are going to be, in some cases, explicitly competing interests with regard to location of certain processes or pieces of equipment. Yet another new aspect of the PHA process, and this is the Ragage Gap review. And so here, again, for program 3, you're to look at whether Ragage Gap has advanced since the process was built and consider any gaps between the standards that were in place when it was built and the current standards, and then document that consideration as part of the PHA discussion that's included in your RMP. So again, here we have yet another a new element and a challenging element, I think, for doing your PHAs.
Once again, if you have a good OSHA PSM program, you're covered by that and have been doing these kind of things, and you're comfortable with your program, I don't think you're going to want to redo your system, but your documentation of what you did. Because the consideration of changes in a Ragage Gap and updates in codes and such should be part of a good PHA review. So I think this, for companies who are used to doing this and doing it, feel comfortable they're doing it well, this is a putting the magic words in the documentation and checking the box so an inspector who's looking at documents says, yeah, they did this, as opposed to fundamentally changing how you do things.
All right, now let's move to wrap up our discussion of the PHA process here. EPA has added new requirements that will make publicly available the company's decisions not to adopt recommendations coming out of the rules specify this as an element of the plan and also identify this as a category of information that is to be shared with the public upon request. And I'll note that this sort of public justification discussion here serves as a bit of a transition slide because the same requirement, as you see at the bottom of this slide, to make declined recommendations part of the RMP documentation is also extended to the findings of third-party compliance audits. But the rule currently requires that the RMP include information about the expected date of completion of any changes coming from the most recent compliance audit. But the final rule extends that documentation requirement, at least when the third-party compliance audit was conducted or was required, that the information include the findings that were declined from the audit and the company's justifications. So again, here, what you have, as noted at the slide topic, is you've got this requirement for recommendations not adopted being provided to the public.
And this is consistent with that theme we talked about at the beginning, the community. They need to know what you're going on, how you're making decisions, what decisions you're making, so that they can be informed about the risks they have in their neighborhood. And that's a big theme of this administration throughout the rules. There's discussion in the preamble about power loss and that a number of the incidents that are reported are around that. This has been an issue for decades. In my early days, before I even was at Lyondell, had the agency wanted us to build a backup power plant to avoid power loss and such. For perhaps a future podcast to advertise that for our clients, encourage it, is that with battery and energy storage, I can see this evolving to where if that really comes into play, that you would have battery storage units at these facilities that could not just keep the air monitoring equipment with backup power, but key process equipment, so key pumps or such, so that you would avoid the systematic dumps that occur when you lose power quickly. So that's a little plug for what could the world look like down the road as we make this transition to renewable energy and battery storage and such.
Yeah, what becomes Ragage Gap with regard to having backup power? As noted on this slide, third-party compliance audits, let's flip over. So the final rule that was just adopted reinserts the requirement to conduct third-party compliance audits in certain circumstances. Now, under the RMP program, you'll know that compliance audits are required every 3 years. And the purpose of that is to verify that, the RMP required procedures and practices are adequate and being implemented for your covered processes. And then in certain circumstances, under the changes just adopted, now those audits will be required to be performed by an independent third party. First is when there's been an RMP reportable release from a covered process since the last audit, and this is the one that certainly has triggered a lot of discussion since it was originally, I guess, really since 2016 or when EPA first proposed this in round one, when the implementing agency, typically EPA, requires it due to conditions that could lead to an accidental release, or when a third-party audit that was required previously failed to meet the certain criteria. But so you have these circumstances in which that internal audit, or typically internal audit, will now be required to be performed by an independent third party. And then the rule further specifies about that in addition to an audit report being generated, an audit findings report, a findings response report is to be generated, and that response to those independent third parties' audit findings must be provided to the audit committee of the company's board of directors.
What I find fascinating about these third-party audits, they put a lot of faith in these, yet a recent CSB report on one incident showed a company who had a third-party audit that completely missed the issue at hand and should have caught it. So the challenge always with third-party audits is getting a good audit. And the independence criteria from, if you go back to round one and such, was so difficult to meet. I mean, there were a number of folks who were saying, hey, I'm going to quit my job and do nothing back because there's not going to be enough people. But now it's clear, a retired employee can come back and conduct the audit. That there should be more of a field of auditors to do well. But if everybody has to do it, there's going to be a difference between the paperwork audit and then the real quality audit that will help you improve. And that's something companies want to look for, is to get a third-party auditor that actually be helpful.
That's an interesting point about, talking about balancing competing interests, where you want sufficient, and you need to have sufficient familiarity to conduct a good audit while also maintaining that independence. And depending on the circumstances, that might become a difficult needle to thread. All right, let's shift gears to another program element. This one, incident investigations. So recall that incident investigations are required for incidents that resulted in or could reasonably have resulted in a catastrophic release. And a catastrophic release is a major uncontrolled fire or explosion or emission involving a regulated substance that presents imminent and substantial endangerment to public health and the environment. And this requirement, those of you that have dealt with implementing this program, you've got to initiate the incident investigation within 48 hours and prepare an incident investigation report with findings and recommendations. Now, what we have here in the final rule is formally recognizing or requiring, I guess is the right term, that incident investigations include a root cause analysis using a recognized method for conducting an RCA.
This was a case where EPA had to be careful what words they chose so that people didn't have to adjust what was doing. So that's where recognized method comes from. Those of you who have quality programs and like your incident investigation reports and how it's going, you should be fine. The one challenge I'd put out to companies to think about is to look at your action items that come out of your incident investigations. If everything is a change of procedure or do more training, most experts would tell you haven't really gotten into the root cause. And EPA will take that position as well during inspection. So there are times when that is the right answer, But if it's always the answer, are you really getting down to the systematic issues on root causes? And there's a whole science behind that. And EPA has some understanding, but not a lot of it. OSHA has far more. But that's something for you to think about as a company. It would do you well to just kind of look at your recent incident investigations and what were the corrective actions.
All right. Now, shifting gears yet again, here are the new employee participation requirements that were included in the final rule. Employee participation is already required as an element for Program 3 covered processes, and the final rule expands that to Program 2 and adds new elements for both. So for both Program 2 and Program 3, with regard to employee participation, you need to have a system for providing anonymous, if desired, reporting either to EPA or to the company or both of hazards, unreported accidents, or other RMP violations, and also give employees access to hazard reviews and other key RMP information. And then in addition, for Program 3 sources specifically, they've added a requirement to consult with employees regarding the conduct, development, and also resolution of PHAs and some other program elements. And then, again, one that got a lot of interest in the round 1 rule stage, adding an explicit stop work authority. So stop work authority must be provided to the operator in charge of a unit for instances where that gives them the authority to direct a shutdown based on the potential for a catastrophic release.
This is where EPA has clearly stepped into OSHA's realm of employees. And for companies who haven't really dealt with employee participation, stop work authority, this will be new and something they've got to think through and work through. For sophisticated companies who have dealt with this for years, once again, probably existing programs should cover it. But once again, you need to watch your documentation and your training, because those are the areas where your EPA inspectors will typically be looking at and checking that box. So that's something that you may not have focused as much on, but for EPA, that's somewhere in your documentation. You need to be able to show that training and such. The agency did at least concede that the employees that should be consulted need to be knowledgeable about the process. So it wasn't a blanket, every employee needs to know everything. They did limit it to those who might actually be useful in the discussion. And frankly, if you are doing a good analysis of your processes and such, you would have already somehow worked with those folks, because the folks on the floor turning the valves, those are folks who can give you excellent ideas on how to improve safety or issues that they're having out in the field. So once again, companies that are doing this well are fine. They just need to look at the documentation. Others that this is kind of new to them need to think it through, and it can have some bumps along the way.
Now let's transition to the final rule's emergency response changes. Recall that the emergency response activities, and we're talking tabletop drills, field exercises, they were one of the only aspects of the round 1 RMP rule that survived the round 2 reconsideration. And also noting here, and it's shown on the slide, that we've got different requirements in the rule with regard to emergency response obligations, depending on whether you're a responding stationary source or a non-responding stationary source. And I apologize for the small text on this slide. A bit of a challenge to make this too succinct. But for both the responding and non-responding sources, the EPA made a change to the requirement about the notification of emergency responders in the case of an accident or a release, specifying that the notice must include additional details about the release. More specifically, it's information that they're going to want and need already, but it's now specified about using the best data you have to estimate what was released and the amount of the release. In addition, and I think more importantly, EPA added this requirement that companies partner with local emergency response agencies to have a community notification system that will warn members of the public in areas potentially threatened by the release. And this is one area where I think the proposed rule had some language that was more concerning, and that EPA's use of this partnering term with local response agencies may provide some relief, such that in a situation where there's a failure in the notification, it isn't necessarily a violation on the part of the company if that is not if it's not directly tied to an act or an inaction by the company. But I'm curious, Stephen, what you think about this one, because we talked about this previously, and I think this partnering language should have some significance for the regulated community.
It does, and that EPA responded to comments that, hey, that's a government job, not an RMP facility. RMP facility is to get the government notified very quickly, and then they execute whatever their plan is for the community. And so they did listen to that about the partnering, adding that. But when you look at the language in the preamble, they still believe that it's your responsibility to limit the impacts on everybody and that you're ultimately responsible for everything, which is an interesting perspective for the agency. This once again goes back to that principle about the community, and that, I can just see the discussions at the agency. Why wouldn't you want to make sure the community is notified? Well, that's a governmental function. I in a prior life, had a facility that it had a release of a certain compound, create a fog on a major bridge. We couldn't shut down the bridge, but we had a direct line to the guy at DOT who could. And that's how this should work, is that the facility notifies the government, hey, we've had this release, and then the government kicks in there. So once again, documenting your partnership and such. And in some areas like the ship channel, this isn't a real issue. There's all sorts of exercises and coordination. It's really out in the rural areas where everything's volunteer. And if they've got several of these kind of scattered over their entire county, they have to take time away from their family or their jobs to have these exercises, to have these discussions and notification plans. And so it's a real burden on them. And so this program covers such a vast array of different sources and locations and communities that it has to look different depending upon the facts on the ground.
Yeah, I'll add one other thing, and it's noted on the slide here about the emergency response exercise part of this. And that was that a requirement in round one that was to conduct these field exercises. And that, again, survived round two. But in round two, EPA had eliminated the mandatory timing requirement for conducting those exercises and allowed for coordination and determination of the timing with local officials. The final reinserts an every 10-year requirement for conducting field exercises, though provides for a different schedule to be agreed to with the local response officials. But it also establishes a requirement to conduct that first exercise by March 15th, 2027. So, and that's a date that goes back to, it's a function of 10 years after the effective date of the round one rule that has sprung back up here. But that is a change, and that is a new thing. And this is the aspect of these recent changes that's going to hit first, frankly, it's by March 15th, 2027, at least as was adopted in the final rule, that is the deadline for conducting that first round of field exercise. So any company that has not conducted it, has not seen it as having that deadline based on what happened in the round two rule, you suddenly do have a deadline 3 years from now, basically, to get that field exercise conducted. Now let's move to the most environmental justice focused aspect of this RMP rule. And we've talked about it in hints in some of the earlier slides, and that is about sharing RMP related information with the public. The final rule identifies a wide range of program related information that must be provided to certain members of the public upon request. That information includes information about what regulated substances you have, safety data sheets for those substances, your 5-year accident history, information about your emergency response program, any scheduled exercises you have, and also, as we discussed, PHA documentation, including when you've declined recommendations flowing out of and your justification for not following up or not implementing those recommendations. So there's a broad range of information that is now to be provided to certain members of the public upon their request. And the company also has an obligation, for example, using the company's website to have an ongoing notice about the availability of that information and the steps necessary to request it. Now, who has a right to this information? That's something that was source of a lot of discussion. as set forth in the final rule, the people that have the right to that information, if they request it, are members of the public who reside, work, or spend significant time within 6 miles of the fence line of the facility. And there's a relatively tight turnaround for that information, 45 days within the receipt of the request. And there's this requirement, again, an EJ-focused requirement about making the information available in English and other commonly spoken languages by the population that is potentially affected. So, depending on your location, you likely have an obligation to maintain this information in some sort of translated form so that you could meet those deadlines rather than start the process of trying to get a translation made for whatever has been requested and get all that done and turn it around in a timeline that is within compliance.
People asking for the information do have to identify themselves. That was one of the things they did to try to deal with the security issues. It's interesting, in the preamble, they talk about how much they talk to Homeland Security, FBI, OSHA, all this coordination effort. But with this many people qualifying to be able to ask for the information, given the era that we live in, there will be a database available very quickly by some NGO that will have accumulated all this information in comparison. And frankly, that's something EPA is looking to happen. They also want all this data to be coming into them to create databases, to give them stuff to sift through, to be able to come up with requirements to add more requirements into the RMP program. Things like, go to ISS and add more passive measures or whatever. They are looking for that. And also, this is an aspect where the community being part of the enforcement, you can bet your justification for not doing something will be put, in some cases, on a local website, or in your next community meeting, you'll be questioned about that. And the public pressure to get you to do, as EPA might say, the right thing is fully intended aspect of the program with the way they've written it.
All right. Well, that wraps up what, in my view, were the most significant program changes that EPA has adopted. This last substantive slide hits a few other items that were raised in the proposal and some changes that were made, a couple key ones that I'll flag before giving Stephen his chance. They did add a record-keeping requirement for hot work permits. Hot work permits, that's been a part of the RMP program for forever, but there wasn't an explicit requirement for record keeping. And I have seen that, and I'm sure many others have seen that as a sore point during RMP inspections and inspectors looking for hot work permits, but not having a rule to point to that directed you to keep it for a certain time period. The last, flipping to that bottom bullet, this was an interesting issue, and there was discussion in the early rounds of this about whether or not companies would still be able to use representative sampling as part of the audit process. And what you're talking about there is, okay, you've got to do these compliance audits every 3 years. And remember, that applies whether you're doing it yourself or you trigger one of these new obligations to have it third party. The issue was, okay, well, do I have to look at all RMP aspects for every covered process at my site? Or can I do a representative analysis where I choose, every 3 years, I choose 1 or 2 or however many different covered processes and use that as a representative sample and to representatively evaluate how I'm doing implementing the RMP program, but in the context of a particular covered process. And there was some language in the proposed rule that gave some concern about that this idea of using representative sampling was not valid, or that the audit had to be more comprehensive and was not allowed to be based on representative sampling or analysis. But the preamble to this rule does confirm that representative sampling is a valid way for performing your every 3-year RMP audits. Stephen, any other thoughts on the topics on this slide?
Just interesting, OSHA doesn't require hot work permits to be kept. And that's who it's really focused on, is the worker right there, yet EPA wants them. You see the vision of what these rules are what PSM versus RMP is different in the two agencies.
So last substantive slide, when do companies have to start complying with all of these new requirements? Now, for most of the changes, the compliance deadline will be 3 years after the effective date of the final rule, which will put it sometime in the middle of 2027. And for updating and resubmitting the RMP to reflect those changes, you get one more year. So you're looking at resubmittal sometime in the middle of 2028. And then there's this other issue, which we discussed earlier about, again, the closest approaching deadline is that for conducting that first field exercise if you're a responding stationary source. Now, I'll say, given the recent history of the RMP program that we discussed on the very first slide, and what's happened over the past 7 years, it seems completely reasonable that some companies may take these dates with a grain of salt. They certainly could be impacted by the 2024 presidential election, as we've seen this program bounce back and forth following elections. They could also be impacted by judicial review of the rule. But those are the dates that are in the final rule that EPA has issued.
This is speculation, but I think it's informed speculation. They pushed everything out 3 years, which typically should be enough time for litigation to hold. So I think they're trying to avoid a request for hold it in abeyance, injunction from enforcing that this can play out, because some of these changes clearly could be done a lot faster than 3 years and some couldn't. But I think there was their effort to try to avoid at least that aspect that you've seen a lot of the recent regulatory litigation that's been going on. But this will be interesting if there's yet a round 4, depending upon what goes on.
It'll just keep our webinar series going. Yeah, all I have to do is I type in RMP on my documents, and there's just this round after round of RMP slide decks that have been generated over the past 8 years. All right, well, that's it for today. I hope you found this helpful. Please reach out to Stephen or me if you have any questions about what we've discussed. And while we're here, please also join us in May, as you can see, May 8th in Houston or online for our upcoming Spring 2024 Environmental Law Seminar. We've got the new TCEQ Commissioner, Caterina Gonzalez, coming in as an outside speaker, and other terrific programming that I promise will be just as exciting as this discussion of the changes to the RMP program. And also, please be on the lookout for other upcoming episodes of our Environmental Essentials webinar series. Thank you so much for joining us today, and we look forward to seeing you in May. Have a great day.